Good evening, everyone. Thank you for joining us tonight. I'm sure there's a lot of you that's been at our previous webinar, and thank you for joining us again. For those who haven't been to the previous one, it doesn't matter. This is a full webinar on its own, so you are welcome here tonight. I'm sorry, I'm just in between having to still admit people. So yes, I just want to minimize my screen. So we want to welcome Monique, our Deputy President. She's going to do some of the talking as well. And then Nolene Pudrezek from Garin CFP is also going to be doing some session. So let me just try. This is a bit difficult because I have to be able to admit people. I have to go to this one specific screen, and then I'm sure you're seeing that as well. Let me just see if I can minimize that screen and still admit. See, where's the people? No, I can't. Let me just do it again. Right. So what I want to do tonight is, before we hand over to Monique for the introduction and for her part, I just want to do a small commercial break. I hope you can all see it when I start. It's a video that's just going to start to play. And yeah, I hope you can all see it. Just get to that slide. No, it doesn't want to go. You know, I can technology. Okay, that's one back. Okay, here we go.
6, 7 CPD points in one day. Yep. It is called the Nexus, happening on Saturday, the 25th of October in Johannesburg. It will be a full day packed with private practice books. We will have good speakers, awesome exhibitions, as well as great prizes. And here's the best part: it is open to all physios, whether a SASP member or not. If you're a student, private practice, go hit that link. Register before the 15th of October. It's gonna be lit. Don't say I didn't warn you. 6-7 CPD. See you there.
Thank you very much. I hope you saw that commercial break. We are very excited about our Nexus, and we would like to just invite all our Gauteng members to come out for the day. We've got really great speakers. I'm sure you all saw the program that went out in bulk email and on our Facebook, WhatsApp groups and Facebook. So yeah, for those who haven't registered, you still have until Wednesday. So please make an effort and join us for our Nexus. Thank you, Monique. Over to you.
Karen, and thank you for that commercial break. I think being involved in the forensic audits over the last year or so, we can definitely see that people think they know how to code or how to run a practice. But when we are consulting with our members, we are realizing that touch points such as Nexus are vital for you to just go and figure out where you're going wrong with practice. So we as a society have done a panel. So we've moved away from one consultant doing forensic audits, and we've now moved to a panel. The panel is anonymous just for the reasons for fear of victimization, but they do represent a group of a number of different SIGs. So that your voices are being heard, so that we know how coding works within each special interest group. And when you are audited, Carden and myself usually have a look at it. It then gets taken to the panel, where we have a panel discussion as to where we think coding issues are, or if we think that you actually have a very strong foot to stand on. So being involved with Carden, we have decided that we're going to do this two-part webinar, where we first invited the medical aides to give their part, and then we opted to have this one where we invite the members to come with your questions, and we can then discuss certain cases or certain questions, or myths, debunk some of the myths that you think, or we see common mistakes happening. I also want to give you some feedback on the case that was launched by the Commercial Affairs. For those of you who don't know, SASP has bought into a company called the SASP Commercial Affairs, and we use this to launch a case an application in the High Court in Pretoria seeking a declaration on the constitutionality of Section 59.3 of the Medical Schemes Act of 1998. The physiotherapists from diverse backgrounds who were members of SASP. The principles of the case were supported by several other professional associations. Unfortunately, they did not band with us for costs, so we carried most of the costs. This was seen as a landmark case funded by us, particular members of SASP, marked a significant moment in the healthcare sector. The case was heard in the Pretoria High Court from the 9th to the 11th of September 2025. We had 16 advocates prepared in opposition, representing key stakeholders, including the Minister of Health, the Council of Medical Schemes, and 9 medical schemes or administrators. The application that we launched was directed against the state, representing the Minister of Health, who bears responsibility for the health legislation in South Africa, and it was not directed to a specific medical aid. The application contains that Section 59.3 infringes upon the healthcare practitioner's constitutional rights under Section 33 and 34 of the Constitution. Specifically, the provision permits medical schemes to adjudicate and enforce disputes in which they are directly involved, a process the applicant argues is inherent of unfair and unbiased. And this is why, as SASP, we decided to launch the case against the state. And I think that's a really good differential we have to make, is that we did not launch it against a specific medical aid or medical aids as a whole. It was about the constitutionality of the 59.3, where medical aids were allowed to be the judge, juror, and executor of forensic audits. What this will mean for future audits, we don't know. We are waiting for the outcome of the case. And based on that, we will then be able to see how this will affect the way we run audits in the future. While we have been engaging with lots of medical aids, we have realized that this is actually going to be the norm for medical aids to audit practitioners. We encourage our members to be okay with an audit. So if you know your coding is on point, we can get you through an audit. And the panel has had, Cotton, you can correct me, 2 or 3 clear audits. So the members were notified of an audit. We submitted the documentation and they came back completely cleared, not having to pay the medical aids absolutely anything. And I think this is where we wanted to come in and say, let's have a chat about problematic codes, what we see are the common pitfalls, so that if you do get the dreaded medical aid letter, that you're not going to be as fearful, that if you know your coding is right, your notes are in order, you should not need to worry. Right, Gordon, do you have anything else to add?
Yeah, I just want to add that it was actually 5 clear audits.
Oh, so 5 clear audits.
Yeah.
That's amazing. Yeah.
Obviously, the difficulty of the audit and the quantum varied a bit. But yeah, we've had the 5 clear audits.
Yeah, so that's great. Seeing that we've only had, I want to say 13. We've had 13 audits as a panel, and we've been able to clear 5. That is amazing news. So we're going to go through the process of what to do when you have an audit. We have invited CFP to give you what to do when you have an audit from a legal point of view. And then Carden and myself and the private sector group are all here to answer any of your questions. Right, I hand back over to Nalini or to you, Carden.
It's to me. Thanks, Monique. Right, so tonight's idea is to explain to you the processes of what is happening with the audit, and then, like Monique said, at the end we will give chance to have specific questions as well. So from the medical scheme point, I'm just going to run through is what is the process from how do they identify and then what do they do after that. So how they identify practices, this is a bit of a recap from the previous one, but there's a lot of people that hasn't been. So I'm just going to run through this quickly. So there is the algorithms that they use, and the algorithms will pick up specific codes, template billing, second condition, like there's a lot of second condition treatments to 0009, and then outliers. So what they do is they look at the average of charges of physiotherapy practices in a certain area, and then they look at it and say, okay, but a comparison to the peers, there's a lot more being charged by this specific practice, and then that's how they are actually flagged, and then they start investigating. So the other way is a whistleblower, and this is actually one of the biggest methods of finding people and starting the audits, because whistleblowers are mainly the patients who will go and complain and say, but they've received a statement and they've never seen this physio and they don't know this person and now they've been charged, or it's gone off from their medical scheme and they've noticed that they don't know this person. Now, what that often leads to is that it might be someone that has got many locums in their practice, and then the patient has never seen the owner of the practice who's actually doing the billing, and then obviously they don't know the practice owner, they don't know the name, they just remember the physio treating. So then that needs to be investigated to see why the patients say that they haven't been seen. Then it has happened as well, that practice location, and that means that it's someone, so people must make sure that when you do your registration each year and you pay your PCNS, your practice number fees, that you always make sure that your practice address is correct. So if you actually change address or you move location, just ensure that you tell PCNS and you correct it with them, because there has been an incident where someone was audited because the practice address is very far from where the patients are. It's two complete separate provinces, miles apart. So they were actually audited because the claims came from a different province from where the patients was actually situated. And when they investigated and the provider could actually give proof of the location of his practice, it came out that he never changed his practice, his location details with PCNS. So they still had his previous addresses. So yeah, so please make sure that if you do move or you do change the practice address, that that is going through to PCNS. And then there's also been, because schemes doing, and it was specifically one administrator that has actually looked at the contracts of the people working for the practice. There was discrepancies with the RWAPs, and I don't know if you know what RWAPs is, but that is for the public sector physios. Or any medical practitioner in the public sector can apply for RWAPs, which means it is remuneration outside of the public sector. So, but they get it's a specific application, and they get specific permission, written permission, that they can spend a certain amount of hours outside of the public sector, even though they're employed by the public sector. So they have actually looked at this practice as locums, and the RWIPS was not in place. So please make sure that your admin and your HR contracts and everything is in place, because they are finding these other ways to start doing audits as well. So once they've identified the practice, they will send the practice, sorry, I'm just knitting in between. They will send the practice a letter, which I call a claims review letter. In the letter, they will state the reason why you have been audited. And say, for instance, it's because they've picked up that you're an outlier, or they picked up that there is an increase in your billing amount, a sudden increase over a period of time, or they will state specific codes that there was flagged in the algorithms. So that will be stated. They then will request sample files from you. It will be either a group of files, or if it's a case that there was a whistleblower saying that they didn't receive treatment, then obviously it will be that specific patient's file that they will request. But in general, if it's algorithms that has flagged you, then they will ask a sample of files, and that could be anything from 10 to 20 files that they normally ask for. And that's the files that they will then review for that specific audit. The audit period will also be indicated in the letter. I will come to audit periods a bit later in the session. So I'm not going to specifically talk about the periods at the moment, but that's what will be stated in the letter. And then they will also state your deadline for response. So it usually varies between 7 and 14 days that you have to respond to them, and that they want you to submit the required documentation. Right. So then what happens after that? Oh, no, sorry. It's first, where's the provider? Oh, I've missed a slide. Oh, there we go. So I don't know why those slides moved on. Okay, so what do you need to do? So once you receive a letter like that in an email, it normally comes via email, then you need to acknowledge that you've received the email, and you need to inform the medical scheme that you are in consultation or you're going to consult with us. So that is all you do. You don't submit any documentation. You don't say anything further. You don't go and write a little story or anything. You literally just say, thank you for the email. You acknowledge it, receipt of the email, and that you will be in consultation with SASP and revert at the soonest. That's all that you write. It's literally just an acknowledgement. Then you need to phone myself, or you can email me. There is my address and my email address and my telephone number, so you can take a note of that. Otherwise, if you don't know, you can just phone the head office and they will put you in touch with me. But you can also email. So that's the important things to do straight away. And then the third important thing is that you have to inform your medical malpractice insurance provider. I'm not going to say too much about what the process is with them, because Nolene will talk us through that. But what you need to do is you need to provide them with a claims review letter, which is the letter that you got. And in most cases, you don't activate the legal benefit yet. That will be a process later, but Nolene will talk about that. So then what do we do as SASP? Once that we get either your email, I will give you a call, or if you have called me, then we will obviously just discuss the whole process. This is why this webinar is quite helpful and useful, because by the time you get the letter now, you will kind of understand the process, which in the past, people didn't know the process, so they will just phone me, and then that is then I will explain the process. So obviously that's the thing, and I will answer any of your queries that you have. I try my best to provide you with medical support. Not medical support, sorry. Maybe medical support as well, but emotional support where I can, and then obviously advice of what is the next steps to do. So then I will also request documentation from you, and it is the sample files, the accounts, and the diary. So what we normally do, the diary is also, the medical scheme will also request the diary. What we normally do is we don't request all sample files. So if you have been asked to provide 10 files, then what we would like is maybe 3 to 5 files, that we can get the trend, that we can see how your accounts are. So at that stage, we don't need all your files. But I will tell you how many you need, or how many you need to share with me. Sometimes I do request all of them. It depends on the situation. So yeah, that is what we need. And then we will also, our panel will review, and we will discuss what we pick up as a trend and what we see is maybe problematic, or what we feel is all is a-okay. We didn't pick up any abnormalities or any issues that we are concerned about. So then we will just give feedback to you. And if it's necessary, we will arrange a meeting with you to actually discuss the way forward. If we think there's a lot of things that we are concerned about, or that we feel this is going to be a heavy, big audit, then we might request an extension if we think it's going to take too long for you to obtain all the files and to do everything that you need to do from your side. So then there is a possibility that we can request an extension. Right. Okay, so once we had the meeting with you and while we are looking at the notes and we are requesting what is going on and discussing, then in the meantime, what we want you to do is to complete the tasks on this tick box list. So you can take a photo of it for future reference if you need to, but then that is what you're going to do in the meantime. So the most important thing is you start with to obtain consent. Now, that is consent from the patient that you are allowed to send the documentation, the notes that they've requested to the medical scheme. So if you can do it via email or you can do it telephonically, but I prefer or I advise the people to do it telephonically, and then once you've spoken to the person, to then follow it up with an email to just confirm what the consent was given. The reason why to do it telephonically is because if you just send an email, the patient is often very stressed out and feeling like, what have they done wrong? And what if are they being audited? So when you speak to them, you can actually explain to them that this is nothing to do with them. They haven't done anything wrong. They are not the one being audited, but for the process to be completed, you need consent to send their details. And then that normally is quite sufficient and they're quite happy with that. If they still say no, then you can remind them that they actually have a contract with their medical scheme when they sign up as a member. They do actually have a contract, and the scheme has got the right to request the notes. But consent is always a good idea first. You can't just submit it without getting the consent. If the patient is really adamant, then what we can do is we can request, we can inform the medical scheme that there's 2 patients that doesn't want to give you consent. You can then say to them that you request 2 different patients as part of the sample. So there's ways around it if they don't give consent, but it doesn't often happen. The second thing you do is you make a copy of the diaries and a copy of the clinical notes. You don't ever send your original documentation to the scheme, because you need to make copies, and then, as I will explain the next step, it's not going to be all the notes that you send or everything in the notes. So it's always important to know that you make copies and you use that copies, and that is what you submit. So once you've made the copies, you redact the diary and then you redact the clinical notes. And what we mean by that is that you only submit what they request. So for instance, if you get a claims review letter and it says they are looking at the 303s and they're looking at a 401, just as an example, and you've done a 501 and you've done a 203 and you've done lots of other stuff, you don't submit anything about the other codes. You just submit the piece that's justifying and explaining what you've done for that specific code. So we don't, and the reason for that is that you don't want to open yourself for further audits. So what happens is if people, and it has happened in the past, people, they don't listen or the lawyer advised them differently. They then submit the clinical notes as is, and they go like, okay, 303 is not bad. They've done everything right for 303. 401 is maybe not problematic, but then they see like, oh, 501, you haven't written enough for 501, and then they audit you for that code as well. So we don't want to open you for anything that they haven't requested from the start. So that's a very important thing to remember. But we will explain that again if you ever go through the audit and the stress takes over and you don't remember this thing, we will explain it to you again. But I'm just putting this in your mind that you know the way forward. And then once you've done all of that and the clinical notes and the diary is ready to be submitted, then you let me know, and then we'll and I will give you the go ahead to submit it via email, and you always CC me in it, please. Right, then what happens after you've now submitted the notes? And then that's normally a bit of time that passes before you get the feedback again. And then once you they contact you again, they will send you what they call a claims review feedback. Now, that is another letter to then say to you what their findings was. Once you've received that letter, you contact us and we can arrange a meeting with you, and then we discuss between, it's usually Monique, myself, and the person being audited, that we have a meeting, and then we discuss the contents of the feedback. You've got an opportunity to explain to us why you don't agree with it, and or you agree with it, or you understand the process or the problems, and we look at that and see, do we as SASP agree, and do we think there's maybe things that shouldn't have been the way that they've stated it. So once you get that outcome, there's two things you can do. You can accept it. If you're happy with saying that you realize that you haven't written notes for, say, 303, it wasn't sufficiently done, or you did charge it twice, which you weren't supposed to do, then if you're happy and realize that it is your error, then you can say to them that you would sign the AOD, and then you negotiate payment arrangements. They can't just come and take the whole amount from you. They can't just say to you, you need to pay 100,000 Rand a month. I mean, it's unrealistic. They can't take away your income completely. So you can negotiate payments. We had a patient, one of our members in the beginning of the year, she had a small audit, and yet she still negotiated for an amount, and I didn't think they're going to accept it. I thought they're going to say to her, no, it's too little that she's paying per month, but they fully accepted with no complaints. So I'm just wanting to emphasize that you do have the right to negotiate the payment arrangement. Okay. Then if you don't agree and you feel that they're out of place and that they're actually ridiculous with what they're saying to you and you want to fight it, then you can disagree. You then go to CFP and activate the legal benefit, and then Nalene will talk further about what needs to be done on their side. And then what we do is we can, from our side, arrange a meeting with the medical scheme and with you as part of the meeting, where this is then discussed. And often, if you do respond saying that you do not agree with this, then they are very open to a meeting. And then they have a meeting with you and we discuss the issues. You state your point of why did you charge it like this, or what is the problem and why you disagree. And you can request an alternative outcome. After the meeting, they will tell you that they're going to now discuss it and get back to you. And then you receive a second outcome as a review letter. And that is the second outcome. Now, the outcome can be different. If they felt that what you were saying is totally agreeable, then they might adjust the outcome, or they can send it back and say, no, it's not adjusted because they still stand to their point. Okay. Then again, you either, if you agree with them then and you're happy and you feel you're tired of this whole process and you rather just pay what needs to be paid, then you accept, sign the AOD and negotiate again for payment. If, however, you still disagree, there is the next step of you can complain at CMS, which is the Council of Medical Schemes. You can lodge a complaint with them. The Health Council has also received quite a lot of complaints from professionals and providers regarding the audits, and they also try to support, and especially where they step in is about the process. If the member felt that they were treated badly or anything like that, then the Health Council does step in and trying to make it more amicable. And then obviously once you've disagreed again and you've done that, the next step is then also legal action. Right, so I'm going to hand over to Nolene that she can tell us from her side and from the medical malpractice provider side, what is the process that you need to follow for them. Thank you, Nolene. Nolene? Monique, can you maybe see Nolene's
I
name on
saw
the list?
Nalene and I saw Lauren is here as
Oh,
well.
Laura, Nolene, hello.
I did see them.
Sorry, there seems to be something wrong with Nolene's mic again. Just give her a moment. She
Ah,
should be
Okay.
no
with us
problem.
shortly.
No
Unfortunately, I
problem.
can't see anything but the screen, so I can't
Okay,
see it.
while Nalene is busy, and so as SASP, we have decided to move the forensic audit benefit as a PSG benefit only. We realize that actually most of the people who are being audited mostly should be all PSG members because they're all practice owners or working in the private sector. If you are not a private sector member, the benefit will be there, but it will be at a cost. We have not yet finalized the cost, but we will advertise it as soon as we do know what the cost is going to be. Right, Nalene, are you ready?
Yes, can everybody hear me?
You're rather soft, but we can.
Then I'm going to loom over my laptop. Sorry, my face is going to be rather large. And is my screen sharing?
No,
It,
I'm not sure. I think I'll have to stop sharing.
Okay.
Nolene, I can see your screen.
Oh,
Okay.
okay.
Let me share again.
Can everyone see? Monique, can you see Nolene's
I
screen?
can see Nalene, yes.
Okay. All right.
Okay,
Great.
excellent. Thank you so much. The presentations so far have been very informative. I can say that I've actually learned a lot. I'm very excited to hear about the panel that I didn't know about. So thank you for that, and thank you for inviting us this evening. Those that are in my team, please can you switch on your cameras for a second so that I can introduce you. On our side, we've got Lauren Brooklyn. She oversees a lot of the schemes and gets involved in more complex questions or claims. And then we've got Lindsay Stutchbury. She assists with the day-to-day members, queries, claims. Unfortunately, Sarah couldn't attend. We've also got a couple from...
I'm here.
Okay. Okay. And we've also got a couple from I2 who are in attendance, so we're happy to have them join us as well. And they would be able to answer questions later if you've got questions about the attorney panel that I can't answer on their behalf. But otherwise, I'm sure we can answer quite a bit for you. But before I continue, I'm going to go completely off the topic. So, hands up if you are privately employed physios on the line, because I'm speaking specifically to you right now. And if you're practice owners and you've got employed physios that are working for you that are not attending tonight, we would love you to just share this little bit of information as well. We will share it through other channels though. So after some thought, discussions, putting our heads together, we decided that 2026 is going to be the last time that we are offering option 2. So what is option 2? Option 2 is the option for 2.5 million cover. It's the option that does not have public and product liability. We thought about it long and hard, and we thought that the cost saving is not really worth the risk. And let me explain why. Some of you may locum from time to time, so you could have a public liability risk. Others might go on home visits for your practice owners, and if you leave a bag on the floor and somebody trips and breaks their arm, they might not want to go after the practice owner, they might want to come after you. Some of you go to sporting events again, so there are possibilities of an employed physio facing a public liability claim. The other thing is when there's a summons, the attorneys can do what we call is a shotgun approach. They don't really know the contracts. They don't know if you were employed. They don't know if you're a locum. They don't know the story. So you can get listed on a summons. And if it's a public liability claim and you don't have that cover, you don't even have the defense costs to move that claim onto your employer. And so we really thought we're going to leave that option there for you if you want to choose it. The difference in cost in 2026 from going to option 2 to option 3 is only 257 Rand for the year. So it's worth the thought. It'll be around for 2026, but we are going to pull that option in 2027. We just really don't think it's worth the risk. And excuse me if I drink water, I do get thirsty during these things. Okay, so what is our role as Guerin CFP? We are specialist liability brokers. We've had the privilege of working with the SASP and underwriters since 2011 to offer a specifically tailored medical malpractice scheme for physiotherapists to our SASP members. As brokers, our role is to negotiate the best possible terms for you. We even negotiate and write our own bespoke wording. We don't use I2 standard wording. And we are very pleased that since 2021, we've been able to keep the medical scheme investigation and audit extension on the policy at no additional cost to you. And this is not something that's commonly offered in the market because of its association with fraud-related risks. When insurers and underwriters hear the word fraud, they just want to be out. They don't want to be in there. But over the last couple of years, we've been able to justify this extension on the basis that in most instances, it's a genuine error. It's a mistake. Maybe you didn't understand the coding. Whatever the situation is, even when you have to pay it back, it's generally not because of fraud. We also provide you with independent advice, and we act as an intermediary. So what does that mean? We are the go-between between yourself and the underwriter's I2. We are here to protect your interests as the insured members, as you are our clients. But one disclaimer here, we are not attorneys. So whatever I say on this webinar, it's not legal advice, it's insurance and financial advice. And we also haven't got a clue about your coding. And that is where the SASP, from what you've heard just now, they are superstars in that area because they can audit your coding, they guide you through the first part of the process. I'll speak about just now how the two work concurrently. So please do as you've been advised, get hold of the SASP to check your coding before you do anything. So now for context, we're actually going to we've pulled the policy wording and I'm going to read it straight up as it is. And then we're going to find out what does this all mean. So what does it say? It says medical scheme investigation and audits. Cover sub-limited to 25,000 Rand in the annual aggregate. The insurer will indemnify you for fees, costs, and expenses incurred with the prior written consent of the insurer in assisting and representing the insured or incurred by the insured in respect of medical aid investigation and audits, provided that the inquiry or process relates to the insured services as defined in the policy schedule, excluding any reimbursement of fees, costs, or charges payable by the insured. So remember, you are the insured. Cover excludes any fees, costs, and expenses with respect to any action which the insured wishes to take against the medical aid provider or scheme. Insurer's total liability shall not exceed the sum of sublimit of indemnity as stated for that period of insurance. The deductible applicable is 2,500 Rand each and every claim. Okay, so that's a mouthful, and what does it mean? So it covers legal costs incurred when you are investigated by the medical scheme. This includes professional legal assistance in preparing those responses. So you saw that the SASP audits, and they will go through your coding, and together with you, you will see if you've made mistakes or if it's correct or whatever the case might be. But where you see that you might face an issue, that is where an attorney could be quite helpful. And they can negotiate and help with negotiating those agreements if that's what you want them to do. Because really, these audits can be quite stressful, and having an attorney at your back is a little bit comforting, or at least I would find it comforting. It's important to note that the attorneys also don't audit your codes. They are not physios generally, and they also don't always understand the codes 100%, and they would even consult with the SASP if required. Their role is to support you through the legal and procedural aspects of the audit, not the technical coding review. Very important is the extension is limited to 25,000 Rand for a policy. And if that audit goes over into the following year's policy, that limit doesn't get reinstated. You've only got that 25,000 Rand to spend. And when you are paying an attorney, I'm sure I too will tell you, they don't come cheap. I will give you a tip later about that. There are a number of conditions on your policy to be aware of. Karen mentions when you get hold of the SASP to review their coding, you need to contact their CFP at the same time. And that's because Sarah or Lindsay are going to register what we call a circumstance. So a circumstance is a situation which might trigger the policy. It might lead to a claim. So at that point, you know you've got this letter from the medical scheme. You don't know if you're going to trigger the policy yet. It all depends. Only when once the SASP has reviewed your coding, and you keep us updated through the process. So if you're going to send a letter that the SASP has helped you to draft, you want to send it to the medical scheme, then pop an email to our claims email address as an update and say, this is what we're intending to send. Is this okay? And we can just keep I2 involved that they know where it's at. Then any amount that you need to pay the medical scheme, say for example, overbilling, that is not covered by the policy. The policy doesn't help you to pay back the scheme. They help you with legal fees to defend yourself and explain your case. So when does the deductible or excess become payable? So an excess is sort of like when your car insurance, you have an accident, they fix your car, you have to pay something in. It's a little bit similar. So when you notify us of an issue or a concern or a circumstance, and nothing happens further. So you get your codes reviewed, it's all good, you can explain to the medical scheme, it's accepted. You just tell us it's accepted, it's finalized, it's done. It can be closed on I2 side and you don't pay that excess. You're not penalized for flagging an issue early. However, if you don't notify timeously, it's a condition of your cover, and you come later, the first question underwriters ask is, when did you become aware of the situation that could have given rise to a claim? And if it's months ago and there's a lot of water under the bridge, they have the right to reject that claim. So please, when you get hold of Karen or her team, please get hold of our team at the same time. Then as the claim progresses, your codes are being reviewed, and then you realize, and the SASP tell you, listen, this is not looking great. That is when you want to trigger the policy and get an attorney to help you. And that only once I2 start receiving those bills, then they will tell us to call for the excess. So here's the thing, when you notify us, you don't have to pay the excess straight away, but you don't know if you're going to pay the excess. So just start saving that little bit on the side, just in case. Okay, let's look at a claim life cycle. How does it actually work? And you see I've run them both in the image concurrently because the process happens simultaneously. So you start by notifying SASP and Guarant CFP. You see it's at the same time. We register the circumstance. This SASP help you with all those awesome things. I think they're pretty wonderful, all the things that they give to their members and help with the coding. Then let's say overbilling is picked up. Then the SASP, you have that discussion with the SASP. You contact our team and we notify I2, and they will appoint the attorney to help you. And negotiations can happen with the scheme at that point as well. The attorneys can help to draft the written agreement, get it signed. Now here's the thing. You only have that 25,000 Rand available. Attorneys charge for every email, every phone call, every meeting, and their charges per hour is not small. So our recommendation to you is to stretch that limit as much as you can by doing the following. When you need to send information to the attorney, gather all the information you possibly can and send it at once. Don't send them today a piece, tomorrow a piece, the next week a piece, because that's going to start racking up fees, and you could run out of a limit. Don't phone them every day to chase them up to see how's it going, what's happening with my claim, because they're going to bill you for those and you're going to run out of a limit. So rather, if you're a bit nervous and you don't know what's happening, rather call our team and we can find out for I2 how's the process going. So yeah, we all need to stretch that limit. So now here you might want to ask I2 later about their panel of attorneys. I'm going to give you the basics. I2 maintain a panel of attorneys and a panel of attorney firms, and they have very specific specialized expertise. Just like medical doctors have specialities, you're not going to go to a podiatrist if you have cancer. You can't use a divorce attorney or a conveyancing attorney or even a medical malpractice attorney for a medical billing dispute. I too have chosen specific attorneys for these types of matters, and they have coached them through how it works, how the policy works, how the SASP works. So they will appoint the attorney who understands also the relevant legislation, case law, and the regulatory bodies, your own, the medical schemes, etc. And by working with this fixed panel of insurers' attorneys, the insurers can make sure that there's a consistent standard across all claims. The attorney knows exactly what is expected from your policy point of view with respect to reporting and your coverage position. They know what limit you have. Also, these panel of attorneys, sometimes they give insurers preferential rates or fixed fee structures. I don't know if that's the case here, but it usually is some kind of arrangement. And that helps the insurers control the legal spend, again, to stretch that limit as far as we can help you to do so. The panel attorneys develop a very strong working relationship with the claims handlers and the underwriters, and sometimes even ourselves as well. We get to know them quite well. And that means these things get handled efficiently. These attorneys have dealt with a number of medical scheme audits already, so they really do have an understanding of your situation, and they also understand the scheme itself that you are dealing with. What is the scheme's personality, you could say. The panel of attorneys gives, you could say I2 is like Big Brother watching the attorney, which also gives us comfort. And you really want to use an I2 panel attorney because ideally you want to have this matter resolved before your limit is exhausted. Otherwise, once it's exhausted, you then start picking up any additional legal fees. Okay, so who do you contact? What do you do? If you ever need to notify us simply of a circumstance, a situation, whether it's a medical scheme audit or any other matter, you can contact us. We've got various means to contact us. Even if you just want to check if something qualifies for cover, please reach out. You can phone us. WhatsApp, we don't take phone calls on the WhatsApp. It's just for messages or voice notes. And you can email us. We encourage you to please reach out if you're uncertain about anything on your policy and to contact us early. Please don't wait. The biggest reason why, and we're not just talking about underwriters and insurers in general, the biggest reason we see claims rejected is called late notification. So don't fall into that trap. And that is it from me. And now we are open for questions. I hand back to Karen or Monique.
It'll be Karen, but we do invite the members to raise a hand while we do have Nalene CFP on board. If you have any specific questions you'd like to ask them.
And even if it's not about the audits, we're okay to answer those too.
Doesn't look like anyone has a question for you. Thank you so much for your time, Nalene. Thank you. Thank you for
a question.
I'm sure they will. They will contact you.
Yes, they're welcome to reach out to us and our team.
Thanks. Thank you so much,
Good
Nalene.
evening, everybody.
Good evening. Good evening. Karen, are you having the rest of your presentation? You're muted. You're still muted, Karen. Sorry, are you on a call? I don't know if you're speaking to me or not. Okay, I don't know. I think Karen's still muted. There
Sorry,
we
I'm
go.
just trying to unmute my laptop. Can you hear me now?
Yes, thank you, Karen.
Okay, thanks. Sorry about that. It muted on my laptop and I couldn't see where to unmute myself. Right, let's just go to the next screen. Okay, so I was mentioning the audit period. So what I'm going to do now, I'm just going to discuss certain aspects so that you understand what is the different periods. So the audit period that they put in the letter depends on scheme to scheme. So for Discovery, for instance, they will ask for 12 or for 10 sample files or 5 sample files, whatever sample they want, but it will be from most likely from the past 12 months. So the sample period is always the past 12 months. But once they've looked at the sample files, the audit period is backdated for 3 years. So the files comes from the past 12 months, but the audit period is actually 3 years. With MedScheme, what we've experienced, it can vary, but most likely it will also be 3 years. We've had some from BestMed that goes as far back as 6 years, which is difficult because obviously to remember what you've done 6 years ago and to see what isn't going on in your notes is difficult. But yeah, so that has been happening. And then we recently had some audits from Workability that we assisted members with, and that was over a short period. So they haven't gone back for ages. It was a recent short period. So how do the schemes actually decide what is it that you need to, or what they want to claw back? So what they do is they use the method of extrapolation, which means that is to infer or project an unknown outcome from current evidence. So they take the current evidence, which is the sample files, and they decide that, okay, if this is what you've done in the sample files, then that is going to be used for the extrapolation of the whole audit period. So that can be per code. So one of this, like Discovery, will send you maybe a letter saying, okay, we've actually identified 3 codes. So what they then do is they extrapolate per code. We've also had from other administrators and schemes that they will say, okay, your claims that you've submitted over the past 3 years, this is the total of the claims, and then they extrapolate on the total claims. If, like I mentioned before, if it's just for because of a whistleblower, someone complaining that they haven't received the treatment, then obviously it will just be for that specific claim that will be clawbacked. So the way they do the calculation according to extrapolation is, say for instance, you've got 10 sample files. The code in question is 303, and that the value for code 303 is 277 Rand City. They then look at the files and they feel that 5 of the files was claimed in error because you did twice 303 for that 5 files, which means that is a 50% of the sample files. They then go and look at all the 303s that was a second charge for that whole 3 years. They see that you charged it 200 times over a 3-year period. You charged it as a second code. They then multiply that with the amount that is the value of the code, and then it works out to an estimate of 55,460. They most probably will take I didn't in this calculation, I just try to explain to you how it works. I didn't take it into account that the fee varies every year. They most probably will use the fee for the year that it was, the value of the fee. that they will use that. But just to make it easy for this explanation, I used 277 Rand 30 as an example. So the total is then 55,000 Rand 460 that you need to claim back for that one specific code that you've done. That is the total. So that is the total of the charges. So the clawback will be 50% of that, which is then the 27,000. So that is how they calculate it. And that they will do per, like I said, if it's different codes, they will do that per code. So say there was 2 other codes that they questioned, they do the same extrapolation, and then your total will add up. It might be just like for this one, it was 27. For the next one, it might be 50. And that is why audits can become so heavy and the amounts can become so huge, because it depends on the amount of times that code was charged. It depends on the percentage of your sample files that was in error.
Karen, are you sharing a you're supposed to be sharing a screen.
I did. Let me try
You're not
again.
sharing anymore.
Okay.
Okay.
Let me just see if I can get back to sharing.
And on Karen's point, so can you imagine if you're a big practice and you have 7 people working for you and you are billing 303 how many times? So that is why, unfortunately, if you look over a 3-year period, that extrapolation can then reach millions. Can you see your shading screen?
Not yet. Let me just try and get to the webinar on
Okay,
here.
can we take Dawn's hand?
Yes, please.
Yeah, go for it, Dawn.
Thank you, Monique. Now, I just want to ask, so you weren't allowed to use those codes all the years, although you've been treating the patients with those codes all the years?
What do you mean by that, Dawn? Sorry?
No, I mean, sorry, if they take back 3 years and the same code, do they then decide that this physiotherapist hasn't used 303 in the last 3 years, but she's claimed it? Is that what they say?
No. So if they say that you used it incorrectly, and in the sample that you have submitted, there's evidence based on your notes that you billed a 303 incorrectly. Then they take that extrapolated amount over the 3-year period and they say, we've extrapolated this figure based on the notes of the sample notes that you've sent us. So if you then say, no, that was probably just a bad physio, maybe I had a locum physio who was billing incorrectly, I don't agree with that. What you then can do is a line-by-line audit to go through every single line where you did a 303 over the 3-year period. And that is the step 2 that Karen was speaking about. That, of course, is a very lengthy process, because if you have a big practice with millions of lines, that's going through every line, taking each file and showing that there's evidence. So that's obviously a much lengthier process. But the extrapolation is where what Karen was speaking about. So that is why Karen will speak to it too, is that your notes need to be really good. It needs to show evidence of what you have been billing. Yes, Karen, we can see your screen now.
And can you still
Does
hear
that
me?
answer your question? And we can still hear you. Does that answer your question, Dawn?
Thank you, Monique. Yes, thank you, Monique.
Okay, so apologies. Now you can see the calculation, I hope. So that was just what I explained. So if you just quickly want to have a second to look at that so that you understand what I was saying, and then I'll continue. Right, everyone happy? Okay. So at the panel, I'm going to raise a few of the errors that we have identified while supporting the people with the audits. And the reason why we want to feed this back is that you can maybe look and see if there's any of these that you are doing and that you can rectify them. Just remember, you can't rectify them in retrospect, so please don't go and change anything. And that was a point that I wanted to say when we were talking before. Then I say to you, you redact the notes and stuff. Just remember, you can never rewrite the notes and you cannot go and change anything on the notes. You have to submit what you have. You cannot alter them. If there is that is fraudulent, And if the scheme discovers that you have, then you will be in real big trouble, and there will be an HPCSA case as well, because you are not allowed to change any notes in retrospect. Okay. Especially if you add something, you have to date when you added it. You need to give a very clear reason why you added it, but you can't take anything that is there away. But you have to date the new date. So if you decide, oh, you did it, you omitted to say that you did some rehab or something, you need to very clearly put the date for today when you alter it, but you can't alter something that's 3 years old. We're talking about the past 6 weeks or so. If there's a file that you've done in the past 6 weeks, but you can't go and alter and add to long-term notes. Okay, so what is the biggest issue that, or one of the big issues that happens with the record keeping of the, because now they're asking you for the sample files. So the things that we notice missing notes. So they will ask for 10 files, and then you suddenly can only find 8. And where this often happens is when people are having hospital practices. So with a lot of the changes that happens in hospitals, people are doing electronic records, or people write they have to write in the records at the bedside, but then they don't make their own notes as well. They just have the hospital notes. Now, that is all fine if it's an electronic system where you can log in and you can download from the electronic system, or you can print what you've done on the notes and you can keep your own set of notes, or you have a specific login detail for the patients that you've been treating, because that means there's privacy and it's secure. But if you don't have that and it's just a Cardex or it's just on the ICU notes, you have to still have your own notes in your own practice where you have immediate access. So the issues that happens is that people say to us, or they submit the samples to the medical scheme, but there's 3 notes missing, or there's 2 notes missing. And then the medical schemes go, well, then it's not done. If you can't offer the files, then you haven't done it. And they will take that as 2 out of the 10. That is an error, plus then the other codes that they find is wrong. So you might end up with 60% of your codes, of your files, your sample files, that's an error. And as I explained, the extrapolation, that will result in a huge audit. So make sure that your record keeping is secured, that you have got the notes, that you've got access to it, and that you can be, if you ever have to submit the notes, that they are available. The other thing is incomplete notes. So people wrote very short, very, very quick notes. They were in a hurry, or we all know that records is a pain because we are treating patients full day and we don't always have time to write the proper notes. The problem is 20 years ago, 30 years ago, 5 years ago, maybe you could have got away with it. It's becoming more and more crucial. And then it's also a Health Council rule that you have to have contemporaneous notes. It must be written at the time. It must be written properly. And you have to have notes. That is a HPCSA requisition. So make sure that your notes are complete. It doesn't have to be 3 pages of stories. It must be just sufficient, well-written notes that doesn't have to be long, but the contents must be fine. The contents is what you need. It's like going to war. You need a weapon, and your weapon is your defense against attacks. But if your weapon is not loaded, there's a big problem. So you might have notes for a patient. So that's great. I've got the notes, but are they loaded? Do you have the right things in them that's going to be able to justify what you've built? So often the other thing is that we find it boils down to what I've just said, is that the notes and the billing doesn't correlate. So yes, you've charged a 303 or you've charged a 501, but what you've written in the notes doesn't really justify a 501. You might have just written mobilization. Although mobilization can be part of a 501, you can't just write mobilization and charge a 501. Even if you spent a half an hour with a patient to look at your notes and see mobilization, no one's going to think that you've justified a 501. you have to explain that you've done the bed exercises or you've done standing balance or whatever else you've done. Or if it is that it's taken you that long to get the patient up because he's that weak, you need to say the complication with the patient. Just make sure that what you've charged correlates with what is written. Then often there is a lack of a date stamp or a time stamp. And the reason why that is important is for the time-based codes like a 509, 501. You cannot justify it necessarily by what you've been doing. So often it's important that the notes reflect time as well, that you can see, oh, okay, well, they have actually spent enough time. That's why the outpatient diaries they often ask for, because the diary can confirm that you had an hour's treatment or you had a 45-minute treatment. That means that there's a big possibility that you have done 30 minutes of rehab. So it's important to have that. Sometimes the practitioner is not identifiable, and that comes in with locums. You need to be able to always, at all time, it needs to be signed, and the PT number needs to be there, that the practitioner that treated the patient is identifiable. And then what I was saying about earlier, that you need to keep your own set of records. You need to have access to it immediately. You need to know where they are. You need to know how to access it. So it's important that you have that backup system of your own set of notes. Okay, let's just go to the next page.
Lauren, I see Yolanda de Jager had asked, how do they statistically or legally determine the amount of files? It has a huge impact on the potential error rate.
So I don't think there is a specific legal way that they do that.
No.
I think that is just that's where the concern about extrapolation comes from, is that practitioners, often feel that, but how can they say that?
I think it's a mute.
As a commute.
No, you're not. No, you're not. I can
I'm
hear
not.
you. Okay.
No, sorry, Liesel is on the phone with the other side, so she's trying to admit people. And she thought she thought she muted me. Yeah, so there's not a specific reason that they give why they do it. That is just the process, and that is where the concerns come in. And that is also why often that you get the member or the practitioner to say, but this is not a fair process. And that is if you feel that, and that's where we're saying that you then can complain at the Council of Medical Schemes, because is it then a real figure? So, Yolanda, I hope that answers your question. And I agree, that is the problem. It does make it very, very difficult. Okay, so then errors with the billing is again the time stamp that the bill is there, but it doesn't say how long the treatment was. Some of the software allows it. I don't know if there's from the older software that doesn't allow a timestamp. I would suggest if it doesn't, then it will be quite worthwhile to change and make sure that you have got that. And then some don't show that it's an AM and a PM. So if your software doesn't do that, make sure that there is a way that you can identify the difference, that you can say to them, so when it comes back and you have to prove why did you charge it twice in a day, then you actually can show that it's clearly according to your patient list or your diaries that it was 2 treatments. And then often it happens the notes doesn't correlate the same date that was billed for. So make sure that whoever does your billing, they need to make sure that they work correctly and meticulously. That we all know that occasionally there's an error, but if it becomes a pattern, that there's a lot of dates that's incorrect. If it's one date that was incorrect or 2 dates over a 3-year period, then that's justifiable because you can show according to your patient list or your diary. But if it's a regular thing, make sure that people do add the correct dates. I see I've got no timestamp again. So that was late night. And incorrect codes as well. I don't know. Maybe this is my presentation doing this to me. Yeah, so then the other reason with billing that is wrong is the incorrect codes are charged. That we will get to the stacking of the codes and things. So you'll make sure that what you treat is what you charge, and that is a valid code. And then with ICD-10s as well, your ICD-10, especially when you do the second treatment, your ICD-10 needs to indicate a good second condition. It can't be similar to what you've done or related. It must be clear that what you are treating is definitely a second condition. And that doesn't mean you go and just choose this ICD-10 code that's a second condition. It must be a valid second condition. So that is just needs to make sure that with your billing that your ICD-10 codes are correct. And also,
I think, sorry, I think that the timestamp is important. Maybe that's why you did put it in twice. Because if you are allocating 30 minutes, if your timestamp says 30-minute treatment, but you charged a 501 and a 303, then the medical aid is going to flag that because your 501 it says uninterrupted for 30 minutes. So in that time, you cannot charge another. So even if your treatment minutes, you could have charged a 303 and a 501 because it allows an extra 2 minutes for you to do other modalities. So maybe that's why. And I think the ICD-10 codes is also a big thing, and I think we see this quite a lot in hospital practices. So we've had a meeting with Discovery where Discovery says that we don't have to use the diagnosis of what the patient is in hospital for. We've challenged them, and they said that we said to them that a lot of the times the software rejects the claims, and then they said that we can email them cases where this is happening. So with Discovery, we do not need to use hospital when we are billing. Am I right to that, Karen?
thank you. Yeah, so what I also mean by the ICD-10 code, it needs to be specific. So if you, and that comes in with GEMS wants you to use the hospital code, then use the hospital code, but always remember to add your physio code, because what they do is when they come to an audit, they will go like, yeah, but what, say for instance, you only use the hospital code for, and it's heart failure. And you don't say what you did as, or has got an ICD-10 code that you added for physio. They will go, but sorry, what can you do for heart failure? And they will actually challenge that. So that could also flag you if your codes are not specific enough for what you are doing. Okay, then trends that we picked up is coding rules. So this, I want to really emphasize this, is that people would actually make effort. Go to our basic coding course. I'm talking about that later, but make sure that you understand the coding rules. That is one of the errors that we pick up. The physios, the providers don't understand the coding rules. They hand it over to point number 2 is administrators and bureaus. So they just say, I've done a chest treatment. This is the patient. They give the patient details. And then the billing bureau or the administrator does the billing and the coding. They can do the billing, but they can't do the coding. So they are data capturers. They capture what the physio tells them to do. That is how it should be. So you cannot just tell your administrator, oh, it's a chest treatment. You need to tell your administrator what codes to charge. Because coming back from an audit, if you do have an audit, you can't blame anyone else that they did it wrong, because it is the responsibility of the provider to understand the coding rules, to understand what is allowed to be charged, and to say what they have done and what they need to charge. There's no blame that you can shift from doing to someone else. You will be responsible for that audit and that amount. And that's why it's very important to take your your coding very serious and to understand the rules. Again, another rule is the modifiable codes. Unfortunately, because of the SASP structure that was there 2017, they suggested changes that you can charge 4 modifiable codes. That has not been accepted. I think there's 3 or 4 schemes that accept it, and BestMed is one of them. But it's not acceptable. It's not the RPL rules. And sorry, I hear myself. Stay with me. Sorry. Is it me speaking or? Yeah, it is. Can you guys hear me? Because I hear very noise now in the background. I don't know if I can hear me. Monique, can you hear me?
Yes, we can hear you, Karen.
Thank you. But it's okay. I hear myself as well.
It could just be the phone that Liesel's using.
No, that one is on mute. No, I hear it through my
It's better
laptop.
now.
Oh, it's better now. Okay.
It's better now.
All right. So with the modifiable codes, which means it's the treatment codes, that's like a 303, a 401, a 203, 107. Those are the modifiable codes, which needs the 0008. That can only be, according to the RPL, you can only charge 3, not 4. So that's also something that gets picked up in the audits, is that people are audited because they've got 4 codes instead of 3. So please make sure that you understand that rule as well. Then what we also picked up was code stacking. So people feel that I'm not getting paid for my time that I've spent, which is true. None of us are ever going to be remunerated for the exact time that we spend. But that doesn't mean you can now go and stack codes, because you will be audited. If you now suddenly have every single treatment that you do has got a 0009, or every single treatment that you do has got a 501. If that is what you really truly do and your notes can justify it, please charge the 501. But don't just put a 501, like I explained earlier, with a mobilization. Oh, I've mobilized, I charge a 501. Make sure that what you charge is relevant and is justifiable. Then template billing is that often happens specifically in outpatients. You see a lot of backs and you see a lot of necks, and you've got this macro code or this together code that you just put in once and it bills the same codes over and over and again. That doesn't mean it's wrong. All I'm saying is make sure that it is, again, justifiable in your notes. Because if you have a practice where you mainly treat backs and necks, your codes are likely to be very similar. But just make sure that when you write your notes that it reflects that you don't, because template billing will actually flag you. It's one of the algorithms that will pick you up. And like I said, it's not wrong, and you will most probably, if it's justifiable in your notes and you can see in your notes that's exactly what you've done for all your patients, that you will most probably be cleared. However, it's a stressful thing to go through. So all I'm saying is if you do the same thing, make sure that you have it to back yourself in your notes. Or if you feel that this guy is not really today, I'm not doing necessarily a 401, then change it to a 310 or something. Don't always just keep it the same because it's the same diagnosis. So that's not wrong, but it's just a warning that it can flag. And then time-based codes, like Monique was explaining, if you charge a 501 and other codes, you need to make sure that your treatment is longer than 30 minutes, because the 501 in itself is 30 minutes. If you charge a 501, 509 and other codes, make sure that your treatment is longer than 45 minutes, because a 509 and a 501 adds up to 45 minutes. So you can't have those 2 codes plus other codes if your treatment is only 45 minutes. So make sure that you charge the time-based codes correctly, and make sure that what you've done for a 501 is, again, in your notes, you can see that you've done sufficient treatments for your 501. And then that's just the ICD-10 code errors that I was talking about before. And that's the trends that we've picked up. So what specific codes we've noticed is a problem? So the 303, unfortunately, and we don't say that we agree with it, but that is what the RPL is stating. And unfortunately, that is once per treatment regarding of how many body parts. So if you feel that you're doing a second condition, You cannot charge a 303 again for the second condition. You can charge 302, you can charge 310, you can charge anything else that you feel is justifiable for that second condition, but please do not charge a 303. Then code 501, what I said is make sure it's 30 minutes, your note supports it, and that you've done more than just mobilization, because that is not acceptable. They will throw you out. They will audit you on the whole amount. And what they often do, they will state and say, well, we've picked up that you've charged 501 for mobilization. Mobilization is a 305, and they will revert it back to a 305, and they will claim back the difference. If they're nice. Sometimes they just claim back the whole amount, but if they're kind, they will just supplement it with a 305. Again, what I said, the 509 is a problem if there's not sufficient time. The 305 is a problem if it's combined with the 501. It is not that you can't charge those two together. If you, for instance, treat a patient in the hospital and you've done a rehabilitation for specific, say, a femur fracture, and then he complains about shoulder pain, and you give him secondary shoulder pain exercise, and you can show that it's a second diagnosis, and you can show your notes that it's a completely different diagnosis in a different area that you've treated, then you can do a 501 and a 305 together. But it is something that flags. Make sure that you don't ever charge it for the same condition together, because you will be flagged and you will be audited. Then the code 0009, it needs to be, as I said before, a really true second condition. It is unfortunately one of the ones that gets flagged the most, or out of my experience with the past year that I've supported the people. It is very difficult to justify that one, especially if the codes are very close to each other. But if there is a clear condition and you can show it in your assessment form, you show that you've identified a second condition, you've differentiated between the two, then you are welcome to charge it. Just make sure that you have got it all, your ducks in a row. And then the one big thing that's happening, and we are trying to fight that on behalf of our members, is that code 405 can be used for passive movements in the ICU. Now, people they treat the lung and then they do the passive movement. So what people have started doing is to charge the chest, and then as a second diagnosis, charge the 405. That at the moment still, no scheme accepts that what we are trying to persuade them to accept, and especially Discovery was very adamant that no, they're not going to accept it. But we're going to look at the research, and we are going to write a position statement on this, because we do feel that although it's an ICU patient and everything is related, you are treating the chest, and then you are treating the strength and the weakness of the patient and the mobility of the patient. It's two different things. And according to us, we feel, or definitely myself, and I'm sure Monique agrees to this because we had a meeting with Discovery, we feel very strongly that that should then be allowed as a second code. But unfortunately, at the moment, it's not a second condition. So do not charge 405 as a 0009. If you want to charge 405, you need to replace one of the chest codes with it. Sorry. So yeah, then the education and training available for you to familiar yourself, to make sure that you understand billing properly, is, again, for those who missed the beginning video that I played, the commercial break. If you're on Gauteng, please to try really hard to attend our Nexus on the 25th of October. We are going to have a session on coding, and we're also going to discuss specific coding errors and things that people struggle with. And you're also welcome on that day to bring your own coding queries, and to say to us, you know what, we struggle with this. What can we help you with? And we can really try to see how we can get you information about it. So, and it's not just on coding. There's a lot of other stuff you're going to also get to know of HPCSA rules and everything else. But please look at the program. And if you're in Gauteng or close enough to Gauteng, please consider to attend our Nexus. The closing date is on Wednesday, so register before then. Then
Karen,
we also,
can
yeah.
we, Karen, also, sorry to butt in. With the coding information, we've been busy with these audits, and these are people that have been in practice for 20 years. A lot of them say to us they've never done a formal training course. They've learned via someone who taught them 20 years ago how to code. And I would encourage you to reach out, come to the Nexus information sessions, because you will probably find out that you've probably been coding wrong, or you've never done, you've never actually spent time to actually learn how to code properly. And these are through the audits that we've been sitting with people. It's like, yeah, my Tanny so-and-so had told me to code like this. And, it's shocking how many of us have never sat down and actually taken the time to figure out if our billing is actually correct. So go to Nexus.
Thank you, Monique. Yeah, I just want to emphasize that is that the defense that they give is, yeah, but I've been taught that way. But by who were you taught? You were taught by, like Monique says, your previous employer or people you worked for years ago or whatever. So please make sure that if you don't, for those not on Gauteng, the other option that we have is our e-commerce courses, which is the basic coding course. It is basic coding, but we often need to be taken back to basic coding. So if you haven't done the course, it's free to all PSG members. So please try and actually do that course. It's just a nice refresher. And then stress management, I stressed it, I see, with 3 S's. So that is the other course that's available to make sure that what if you charge a 506, that you have sufficient techniques that you've done. So there's a position statement on it available on the website, but there is a e-commerce course that you can actually attend on that. So, and then there's also ICD-10 courses. There's one purely ICD-10, and then there's one of ICD-10 and the PMB. Then documents, there's a document on the website. I was planning to just double check the name of it. I know we had a webinar on it 2-3 years ago, and we called it the interpretation of coding. And I actually saved it under interpretation of coding, but I just need to go and double check what the document is called. Francis, I know you actually mentioned it the other day to someone, so if you can remember, just let me know what that is. Otherwise, I will actually, in the next bulk email, I will send out the correct name for that and the link to the document. And what that document talks about is codes that we've, before the audits, we've picked up some codes that's problematic. And we've actually done an explanation of what exactly does 501 encompass, what is supposed to be part of your treatment for 501. So for instance, 501 doesn't mean it's 30 minutes of exercise. It can be your advice. It can be your prescription for exercise. There's a lot of things that can be part of the 501. So please, I will send it out the name if it's not interpretation of coding, but go and search the web and you can just look at what is the specific codes in there. And then again, the position statement, like the 506, is also available on the website. And then support. The support is, we've got the coding portfolio, which is currently John Earcoat. Previously, it was Francis. And then we also have myself. So if you have any queries about coding and you're really uncertain, rather check and make sure. We can't give you advice on saying, code that. We can never say to you what to code because we're not allowed to see that it's collusion or it's price fixing or whatever. We can never tell you exactly what to code. That is up to you because you only know what you've treated. But if you don't understand a code properly or something gets rejected, you're welcome to check with us, or you want to know, am I fairly, so just an estimate of, are your way of billing, is it correctly, or your coding, then you can always reach out to us and we are there to assist you. Francis says she can't type in the chat, but I don't know what is her answer. Right. So what I want to give you cues to take home and what you need to get about the
Karen.
audit. Yeah, Francis?
Yeah, I did give you. Yeah, I did give you the answer. It's but it's the where the it's called problematic codes. That was
Uh,
the document.
Okay, so that's what it's on the website, is problematic codes.
Yeah,
Okay, great.
yeah.
So thank you for that, Francis. Okay, so you can just search on the website problematic codes and you've got access to that. Okay, so my things that I want you, important cues to take home, is hold your head high if you get an audit. It's not something to be shameful about. It doesn't mean you're a bad practitioner. It doesn't mean that you've done something wrong necessarily. Obviously, as we go through the notes and you have done erroneous billing, or you've done something in error, we will deal with that as we go on. But it doesn't mean you are fraudulent. It doesn't mean necessarily that you've done something huge. It's not shameful, because I can tell you that so many practices are going through audits. I think years ago when it started, it was a very hush-hush because people were feeling like guilty and they felt ashamed. But that is why we're doing these webinars, because we want to show you that it's a thing that happens. And like Monique said earlier, it's not going to stop. It's always going to be there. It is a process that we all, or most of us, will at some point in your practice go through. So don't feel that you have already done something wrong. The approach from the schemes, and especially from Discovery, from years ago to now, has definitely softened. The letter that you get now is much more kind than the letters that people got 5 or 6 or 7 years ago. So there has been a change in the way. The meetings we have with them, they are very open to hear your side of the story, to discuss. So there is definitely a softer approach, and we are really trying to make this not shameful and that this is a normal process. So that is my big message I want to give you. Then audits are not clinical. So please don't think that you are a bad practitioner. They don't question your clinical skills. They don't question your clinical reasoning or whatever you've done. They see data. They see an account, a claim that comes through, and they decide, okay, does this make sense with the ICD-10 code or whatever? It's been flagged. Then they look at your notes. If your notes doesn't justify what you have billed, then that is a problem. But they're not questioning what you've done with the patient and what treatment you've given. They only say, you've charged a 303. Is there enough efficient evidence in your notes that you've done a 303? If it is, you don't have a problem. So it's a very emotional thing, and I've been through an audit myself a few years ago. So I know the stress, and I understand the feeling that you get, that, oh my word, they're attacking me on my clinical professional skills. I know I'm a good physio. I know I spend so much time with my patients. I'm really an in-depth physio. But so immediately you think, oh my word, they are questioning my skills. That's not what they're doing. It's a financial decision. So that's my second thing I want you to take home. Then always, always, always remember your first step is to contact us, and you can do it before or after you acknowledge the email. So those two steps goes hand in hand. But please don't try and do this on your own. The people that don't contact us, they come back later and they say, okay, they've now received this claims review. But by then, it's really hard for us to support you. And it's hard for us to turn anything around at that stage because they've already given you the claims review that they want to claim back. So don't submit the notes. And then also the people submit the wrong documentation or too much documentation. So please, the first step, remember, contact us first. And then be cooperative. Do not be aggro. Do not feel you've been done in and now your attitude shows it. If you're cooperative, and we've been through a few audits this year, if people cooperate, it is a much easier journey, and it's a much more pleasant journey, and the outcomes are good. If you're not going to cooperate, you suddenly feel you're going to call a lawyer. First thing that you do is you call a lawyer. You then feel the lawyer must write a letter. Please, people, that's not the way to go. The way to go is to be cooperative, trust the guidance that we give you, respect the deadlines that they give you in the letter. If the deadline can't be reached in reason, then we ask for an extension. Respond promptly. Don't wait weeks on end before you actually respond to any email that you get from them. If they say to you they want a meeting, respond and say that you'll get back to them with a date or whatever, but do not just keep quiet, because that's been seen as non-cooperative. And then stay calm and keep perspective. And why I'm saying that is we are, well, a lot of us are emotional beings, and I'm one of them. And it's very hard to sometimes take our emotions out of something like this. But if you're in a meeting with Discovery or with any of the schemes, or you're in a or you get an email, and you want to respond to it, try to take the emotions out of it, because state the facts. An emotional waffle about why should you charge this and why this is correct is not going to actually help. So let's just stay calm, keep perspective, write the email you want, and then change it back and take out the emotions. So before you send it, so just make sure that you actually have just clear facts, and then have patience with the process. You might do all this according to the deadline they've given you, and then they may take 2 weeks, 3 weeks, a month before they come back to you. So it is sometimes a quick process, and sometimes it's a long process. It depends on how many claims they need to go and look at. So sometimes there is a time delay in their response before they send you the claims review feedback. But please just be patient. Then again, what I said earlier, don't alter any documentation. You cannot do that. That's fraudulent. And obtain all clinical notes. So if they ask for 10, make sure that you can give them 10. Even if you have to drive to another town where you've treated the patients in a hospital, then you do that. If you need to make all effort to get the sample to them. So if they ask for 10, try to get that 10. And then again, the take home is, yeah.
What happens if the patient had died and you can't get consent?
So in that case, if it's consent, in that case, you can email them and say, unfortunately, this patient can't give you consent, the family can't give you consent for it, and can they provide you with a different request? So then they will say, okay, give us these two or this patient instead. So you can explain to them why it's impossible for you to get the notes, and then you can request a different set of notes. And then again, submit only what is requested, redact anything else. And then what I mentioned previously, your clinical notes is your main weapon, and that is what needs to be loaded. Right, so
can we give Josh and Jayashree a chance to speak?
You're welcome. I can't see the hands, so thank you, Monique.
Go for it, Jayashree.
Okay, so I think most of us use the code 303. So I just want to know how much detail in our notes should we go into. So say, for instance, it's myofascial release. Must you say I release the lateral fascial line and I found a trigger point in the upper trap, or what do you write for a 303?
No, what you can do is they often will, if you write myofascial release, they most probably will accept it. But it depends on the auditor. Sometimes some auditors are more difficult. So if you just wrote myofascial release, shoulder, forearm, elbow, or something like that, where you don't have to specifically go into say, like you now mentioned, the exactly bands and the stuff that you're doing, or the trigger points exactly. But if you can say myofascial release, shoulder, upper back, lower back, then that will be sufficient.
The issue comes in, Jayashree, if you're charging a 303 twice for one treatment. So that's the issue. So if you're just charging it for one and you're just like MFR, hip, back, whatever, that's fine.
Okay, all right.
Yeah.
Thank you.
Okay, I want to quickly ask if there's any person on the website. No pressure, but on the webinar, no pressure. But if you have been, Sifiso.
Hi, Sofiso.
Good evening, everyone. Just a quick one. Thank you very much. The presentation was informative. I just want to ask something. Let's say, for an instance, I've been maybe coding 501, maybe for 5 years and something like that. So then now I attend the coding class or coding, whatever you call it.
Course.
Then I decide to do the right coding and stuff like that. Won't it flag to the medical aid that maybe there's something wrong, and how do we deal with such?
So Monique can add to what I'm going to say if she differs from me or not. But the thing is, the whole idea with audits and the thing that what the medical schemes want because of audits is changing behavior. So if they
Yeah.
pick up something that is wrong, they want it going forward to be changed. If you now decide out of your own, you've now learned more about coding, you're going forward and you're changing it, it's not the change that should flag you. The fact is you most probably would still be flagged on a 501 that has been charged too many times or incorrect or whatever. But if you can then explain that why you've started charging differently is because you've done a course and now you know for the better, then that's not going to flag you because you're changing your behavior.
Oh,
So the
okay.
whole thing is what they want is change in behavior of bad coding.
Okay.
Yeah,
Okay.
so we're also seeing that a lot of people are getting into trouble because they're trying to avoid the 501. So now people have become averse to charging a 501, but then they start charging a whole lot of other codes to make up for the price of the 501. And that is
Oh,
where
that's
they're getting into trouble because the clinical notes are not reflecting what they've done. And we've had meetings with Discovery with practitioners, and Discovery would saying, but you could have just charged the 501. Why were you charging all of these things? And the answers that we get from the physios are, no, I tried to save money for my patients. I didn't want my fees to be as expensive. So I chose a lesser code to not make it a 501. And this is unfortunately getting you into trouble. And one of the things that that Discovery always says to our physios is, it's not your fault that your patient chose a lesser plan. So I know we're in physio because we all want to save the world and we want to be good people and we want to help our patients. But at the end of the day, don't change your billing based on affordability just to help your patient out because you're going to be in trouble for that. So charge code what you did, even if it is a 501, even if you and speak to Colin about how to make your practice value. Make sure that you are coding correctly. You don't have to stack codes to reach a certain amount, or that you are trying to lessen the amount by putting in cheaper codes.
Yeah, and I
okay.
want to
I hope
add,
that answers your question, Safisa.
Yes, you did. You did. Thank you.
Thank
Thank
you.
you.
and I want to add to that. I think a lot of practitioners has become, after all the stuff they hear about 501s, if you are doing a 501, please charge it. And especially what also happens, some people will put a second code to, especially a 0009, and then they charge the 501 as a 0009 to say that it's an additional code. But what we've then been able to do is to say to the medical scheme, okay, it's an error that they put it as a 0009 because the 0009 got flagged. But to say that they could have charged the 501 with the first code, because you can do a standalone code together with the modifiable codes. So don't just go and use a second condition for the 501 because you're scared of the 501. If you've done a 501 for the patient and you've treated, say, the chest, and you've done enough rehab with the 501, charge it together as a first diagnosis, because the chance that you'll get flagged because there's a 0009 is much bigger. Okay. And if you've done it, then charge it. Just make sure you follow the right rules. Right. So what I wanted
See
to,
another hand, sorry, and there
okay.
is Tay, I think it is.
Thanks, Monique.
Hi, yes. I just wanted to ask, you mentioned the chest and the 405 in ICU with the passive movements. Does that mean that you can't bill a through, like if you're not doing a 501, let's say you're doing a 325 and a 405, that they would flag that as an issue? Or is it adding it as a secondary condition and then
Secondary
charging the...
condition.
Okay,
Yeah,
so you
that
can do a 325 and a 405 and it won't be flagged for
100%.
an issue. Thank you
100%.
so much.
Yeah, you can just not. What the trend is that people starting to add it as a second code because then it's an additional code and it's more money, because it's more time to treat the passives as well. That is where the problem is. If you replace one of the codes for the first condition with the 405, no problem.
Thank you so much. Appreciated.
Pleasure. Are there any other questions, Monique? Any other hands?
No, I don't see any
We
other
have
hands.
got, yeah, we've got questions still at the end as well, if there's something people think about. I just want to know if there's anyone on the webinar that would like to or wants to or has got the guts or the to share if they have been audited and if they want to share their journey with the people. If you are willing to or you want to say anything about your journey. I can't see the hands, Monique, if there is any.
I will let you know if they pop up.
Okay.
Barbara. I see Barbara Pretorius. Yes, Barbara.
There, my mic's off. Good evening. I'm Barbara, and I was audited. It's about 3 years ago, and it was very, very difficult for me. And what I would just say to everybody is really try and keep the emotions out, because I just took it very personal. And I mean, even now, I still feel as though they were saying you are not good enough as a physio. And I think if I had a more, what's the word, balanced mind or balanced emotions, where I didn't take it personal and just said, okay, you made a mistake, you billed incorrectly, you can fix it, and if you have to pay money, it's okay. I would have handled it much better. But for instance, filling in the forms and doing the records, I totally procrastinated because I just felt so frozen. And yeah, that arm was not good enough. And to make it worse, it was over Christmas and New Year. So yeah, it was just a very hard time for me. And I just want to say that if you get that email, first of all, as you said, contact the SASP and let them help you. And then number 2 is don't take it personally and just go through the motions without making it personal. And then the other mistake I made, well, I feel it's a mistake, is I first used an attorney's help, which in the end cost me a lot of money, that if I was more better in my thinking and reacting and the way things were done, I would not have gone that route. And I would have just let the SASP help me. Because in the end, I did manage to get the amount right down. There were a few patients that I billed incorrectly and I paid that money back. But in the end, my attorney bill was over 65,000 Rand. And that just made everything much worse. And that was more of a problem. And especially being a sole proprietor in your own little practice, in your own little place, and now you have to find 65,000 Rand for a lawyer, was not a joke. So all in all, I've learned my lesson, and I can just say if anybody needs a shoulder to cry on, I'm here. I know how you feel. And yeah, try and do your, what did you call it? Your you're redacting
Redaction.
yourself, and don't think the attorney's there to help you, because they're not. And even the one day I was debating with the attorney, and she said to me, yeah, but you've seen this lady so many times and you've charged her all these things. I said, yes, but if you read the notes, unfortunately, that lady fell and broke her arm. Then 3 months later, she drove her car into a wall and she had a whiplash. And then 3 months later, she fell and broke her hip. So over a year, I did a lot of treatments with a lot of money, and I didn't even charge her for everything I did. And then she was flagged that I overtreated her and I overcharged her, which was not the case. Yeah, so be calm and accept help. And yeah, that's my story.
Thank you, Barbara. I really want to say thank you for that. It's very valuable, I think, to hear from a practitioner that's been through it. And I just want to or emphasize again what Barbara just said. Do not make the lawyer your first port of call. They are expensive, and do not let them submit the notes on your behalf. It's very easy to submit the notes yourself once we've given you the go-ahead. You just add it into your email and you send it to the auditor. In cases where as Nolene said, they start charging at the first minute, and they charge you by the time you haven't even gone through the audit yet. You've literally just submitted the notes to them because they've met with you. They look, they gather the notes, they gather the letter. Don't let them acknowledge the letter from receipt as well from the claims review. You can do it yourself. It is very easy. You just acknowledge it and inform them that you're contacting us. Everything they do, they charge for, as Nalene said. And by the time you really need them, then the fees are already used up or very, very high. So please make sure. And then the other thing I want to say is that they do not understand the coding. They do not understand the clinical notes. That is why SASP is involved, to look through the notes, to advise and to see, can we fight for something? Can we bring down the amount? Because maybe we can say, but in the end, you could have charged this instead, and it wouldn't have impacted on the scheme. But the lawyers can't do that. So we work with the lawyers when it gets to that point. But we have had some that we cleared without having a lawyer close to us. So it is not the first step. Please contact SASP. So thank you, Barbara. I really value that you've just shared. Yeah.
Thank you so much, Barbara. And I want to also just re-emphasize what Barbara says, is stay calm. It's not a clinical judgment. They're not saying that you're a bad physio. And a lot of the times, we've been in a couple of meetings with Discovery. They bring physios to the meeting. They employed physios to deal with physio cases. So these people know the protocols. They come with clinical protocols to us. So these are not the Discovery and the medical aids. They employ medical staff to run the audits for them. So it's not a clinical judgment. It's about coding. So don't think that you're a bad physio or that they're questioning that you're an unethical or bad physio. It's purely clinical. It's purely coding. It's numbers. It does nothing to do with your coding. And also Barbara highlighted the fact that this is quite a psychological, it's emotional thing. So don't pay for the lawyer, pay for a counselor, pay for a psychologist to help you through it. Your money will be much better spent. And then if need be, you do have CFP. CFP is giving you 25,000 Rand cover. But we work with CFP and I2 to make sure that we tell you when to activate that. If we can get you through an audit beforehand, that's great. Also, something that I wanted Nolene, if she's still on the call, to talk about is, if you have not informed CFP that you had an audit, and you run your own audit independent of SASP, independent of Nolene and her team, and it gets to the IOD, the last time we spoke, Nolene said that there might be a surcharge to that. Nolene, is that still the case? I don't know. Are they
Okay,
still on
so
the line?
I'm still on the line. Can you hear
Yes.
me?
Yeah, I
Okay.
can. Yes.
So on all medical malpractice insurance policies, so I'm speaking even to those who might not have our cover here, all of them say that as soon as you have anything that could possibly trigger the policy, could bring about a claim on the main section or any of the extensions, the condition is that they must be notified early before anything else, because those policies, all of them, say that the underwriters have the right to decide on how a claim is managed and how it's run. They have the right also to decide on attorneys, etc. Where I2 has been awesome is that they have given some leeway, concessions, we could say, for the SASP to get involved so that a lot of the work can be done by you and to do the coding reviews and to answer where it's appropriate, etc., and not to trigger it, because the triggering of it does two things. Firstly, then the physio has to pay the 2,500 Rand excess. And it also affects the loss ratio on a scheme. So more claims, more costs, then more increases at every renewal. So I think everybody is playing very nicely on this front to manage those claims, to do it right, so that physios don't have the experience of Barbara, where an attorney might get involved too early. And like I said in my presentation, they don't understand the coding. I don't understand the coding. When I go to my physio and I get billed, I don't know what that thing's all about. I just see the price. so that is where you guys, the SASP, are really giving, to me, it's an invaluable service that you're giving to your members. And if I can encourage everybody on this webinar, please go to that training. It's not just for the audits, because if you have, and we had a meeting earlier with today with the SASP, and we showed them some of the claims figures. More than 50% of claims don't hit this extension. They hit the medical malpractice section, where somebody's alleged to have made a mistake, an error, or negligence. And that coding and those clinical notes have to match for the defense of that physiotherapist. So it goes far beyond this audit. This audit, in our minds, I know it's emotional, it's terrible, but for us, those are the small claims. If you get a big claim and your coding is wrong and your notes are wrong, that is a whole nother story.
Yeah, and that in our previous webinar, we did have HPCSA on as well. And unfortunately, the medical aids are obligated when they find that you don't have clinical notes to report you to HPCSA, and that is a long case. Yeah, thank you, Nalene. And then, Gordon, Yolanda's hand is up. Is it Yolanda? Sorry, just check the name.
It's
Yeah, Yolanda.
Yolanda, I think. Yeah.
You can go for it, Yolanda.
That's okay. I think at the next, there's another one. Eber?
Hi, good evening. I just want to know, man, it's probably not for this talk, but is there any move in getting other codes, more specific codes, codes that are better worded, they're not so ambiguous like the 501, you know? Just to make things easier, things are progressing. There are other treatment techniques, there are other equipment that is used as well, so is there any change in that? Because it's the same coding and billing since I started practicing 20 years ago. The codes hasn't changed at all. So
Yeah, that's true. That's true. We actually did a block exemption with application to do this, and it got rejected. It was part of the massive block exemption that happened earlier this year. So we spent money on it. We had to actually look at it, and unfortunately, the government Competition Commission came in and did a block exemption. Discovery has reached out to us to look at alternative codes, which we will explore this year sometime. Hopefully by the end of this year, we will have a meeting with them. But when it comes to a complete new coding structure, we've been halted by the Competition Commission, unfortunately.
Oh, okay. Hopefully we can get something right with Discovery, because it seems if they give the go ahead, then the rest just follow.
That's 100% true. If you haven't seen we did send out a notice of the block exemption, and we sent it out to all members. I think it would still probably be on the website, our application and the block exemption explained, Eva. But yeah, we not for the lack of trying. SASP is extremely busy. We are fielding all of your questions. We are listening, and we are trying to action as much as we can. I saw Yolandi's hand was up and down again, so maybe she's able to unmute herself. We're not able to hear you. I see you're unmuted, Yolandi, but we're not able to hear you. Maybe you want to type it in the chat?
Can I just ask a question while Yolandi is typing? So
Yes,
with Netgear, we use the K-On, and all our notes are on the K-On system, and we make quite good notes. And they are there's templates for notes and outcome measures and things on there. So
yes,
seeing that it's there and that we have our logins and that, if I understand correctly what you said, we don't have to print out those notes and put it into folders. We have access to it, so when need or called upon, we can just export it and print it. So that is absolutely fine that way.
that is fine. We did have a physio earlier this year who was also on one of these programs. For some reason, he got other people to do his work for him, I got him, another practice, and he didn't have access to the notes. And because he didn't have access to the notes, his audit shot up because he was not able to provide the notes that Discovery wanted. But yeah, so
No, because
you
Netgear is
outsource
putting in.
your work. Yeah.
Netgear is really ruling that out now, where they are working on other people's logins. Each individual practice, each individual physio within the practice should have their own login. Yes, so they are working on that. Yes.
Oh, perfect.
Thank you.
Perfect answer. Thank you.
Okay, Monique, can you see the chat if Yolandi did write anything?
So I just saw that she typed a couple of minutes ago that her mic is not working, but I see another question from her that says, it happened to us. One of the sample files was deceased. They still wanted the file and it was used as part of the extrapolation. And then Karusha said, if you're being audited, is there a separate fee that you have to pay to SASP? So no, not if you are a PSG member. For this year, it was open to all SASP members. As of next year, we've moved it to only PSG members, and there will be a fee if you are not a PSG member. So, and then Zenith says, will there be a Nexus event held in the Western Cape? so Pardon, I hope you come into the Western Cape. We will support you. As Cape Townians will support you.
Yeah, no, just on that note, we are planning to do nexuses every year in different provinces, and hopefully this was our first year. So we've done one in Gqeberha and we've now done Gauteng. Hopefully for next year, we'll be able to do 3 at least. We're trying to do smaller provinces and the big province. So hopefully 2 smaller ones and possibly Western Cape or KZN, we'll see. We haven't planned yet, but yeah, it's going to be rolled out every year in different provinces, but we're going to try to cover at least 3 per year. Okay.
Perfect. And then
Right.
Yolanda typed her thing. She said, I wanted to share that we went through a massive and lengthy audit 2 years ago. The help from SASP was invaluable, as well as the financial assistance from CFP. So that's a nice, good story, good-hearted story. So
Thank you. I've got another good-hearted story that I want to share on the next screen, if my screen just wants to go. This was one of the members that went through the audit this beginning of the year. I don't know if you can read it, but I'll just read it out. I was audited 5 years ago during COVID without SASP assistance. That experience was isolating and frightening, and I eventually had to seek legal advice. My last audit, following the process set out by SASP, was completely different. From the very first day, I was guided through every step. The support was outstanding and Karen phenomenal. Thank you for this vote of confidence. providing clear communication and reassurance even over weekends. This led to a far less stressful experience and a very favorable outcome. The difference your team make is profound. So yeah, just on that note, please, people, we are really trying hard to be there for you and to make this journey a lot easier. And then questions, if there are any more. I know I'm conscious of the time. We are about 6, 7 minutes or 9 minutes over time. But if there are any more questions, we can take a few. Anyone who wants to ask something else? Dawn?
Yes, sorry, I just want to ask. Barbara said a patient was flagged. So do they actually phone the patients and tell them that your physio is being audited? That patient that was there so many times.
No, she, what was quite ironic is that she actually said she paid me too little, where I just charged the normal discovery rate for what I did on that day. But some days I treated all 3 joints, and other days I only concentrated on one. So it was a difficult account to manage from an audit point of view. But and that was not one of the accounts that was flagged in the end. But no, it wasn't the patient. She just wanted to pay me more, and she was very happy with my work. And she said Discovery didn't charge me, I didn't pay me enough for everything I did for her. Because we spent about a year on rehab and getting her back on her legs. And I mean, she's now 80 and she's still running around and doing a thing. And so, yeah, no, it was just an unfortunate situation. No, none of the patients complained. They were shocked. You know, when I got their consent, they were all like, but no, we didn't pay you enough. And no, man, Discovery is wrong. And yeah, so no, it wasn't the patients.
Now, because I understood you said that Discovery flagged your
No,
patient. So
no,
they didn't phone her and tell her that you are being audited.
no,
Oh,
no,
okay. No, I just was concerned about that.
no, it was the lawyer.
Okay.
The
Thank you.
lawyer
Sorry.
didn't understand what I was doing with this patient for a year.
Okay, thank you.
So the only time they will alert the patient is if your practice has been blacklisted by the medical aid, and that usually happens if you are uncooperative in the process. And the medical aid then goes through a process where they blacklist your practice, and then an email gets sent to all the patients that you've seen to say that they are no longer accepting direct payments from this practice. So that's the only time that the funders would alert the patients to an audit or a failure of audit. And this is why Carden said communicate. You have to communicate with the funder. If you just stay quiet or ignore the letters, that becomes non-compliant and they blacklist you.
Thank you, Monique. I don't know if you can see any more hands, but I think due to the time, we will stop there. If there's any other questions, they are welcome to email me or then ask me at Nexus. Sorry?
Or go to Nexus.
Yeah, that's what I wanted to say. Or ask me at Nexus or ask legal or our committee at Nexus. But yeah, so if there is anything, but thank you for attending. I hope you found it all very valuable. And please, if you do get that dreaded letter, just contact us first. Thank you very much and have a lovely evening.
Thank you all.
Oh, Bruce has got a...
Yes. While we're still here, ask her. Go for it, Bruce.
I know it. That was my fat fingers missing the thumbs up button. Thank you very much, guys.
Oh, okay, thanks, Bruce. I thought you wanted to ask something. Thank you.
Bye.
Good night, everyone. That's it.
I can't stop the recording. Maybe you should stop the recording. Can you stop the recording?
I've done, yeah.
Ah, cool. I can't even